any questions for Attorney Pippen, we'll ask them the next time he's on, because he comes on with some regularity. And welcome back.
Thank you. It's great to be here.
Yeah. Let's take just a second. You have a radio show. Is it called?
It's called Ask an Attorney.
When is it on?
It's every Saturday morning at 8 o'clock.
On WFLA?
It's on multiple stations all through Florida.
Okay.
I'm now also streaming the program on Facebook Live. And there's a website called webeamtv.com. They can watch a stream of the show on Saturday morning at 8 o'clock if they want. Okay,
and I so appreciate this type of show. Sometimes you have a financial planner or something on, but you can really glean some good answers. And I've listened to Joe's program, and I thought, I wonder if people realize they're getting something free here that's usually for sale, and they don't have to drive to the attorney's office. And
it's always good to have a little more information.
Yeah,
you never can have enough, I think.
Okay, here's the first one from one of our employees here at the station. My wife was wondering, she is the POA, power of attorney, for her mom, who is in memory care assisted living. She has no assets to speak of, maybe $5,000 after funeral arrangements. Since there's no will or anything, is there anything my wife can do with whatever's left?
Well, if the person has minimal competence to do their will, that might be good, because then the personal representative, maybe her daughter, could be appointed. Some of these questions are a little hard to answer because you don't know if there are other children involved as well. But $5,000, she could also possibly just make that a paid on death account, so there wouldn't be any assets in the estate at the time.
What is paid on death? What is that?
You set up a bank account or a financial account, and the account has a named beneficiary on the account upon death. Now, I don't recommend that for most people, but on real small amounts in a question like this, that might work. She could also put daughter on the account as or, mother or daughter, so daughter can have easy access to writing checks. If mother could still focus, if I went to see mother and she could focus and do you want to do a will? And she just shook her head and we had some focus going on. Do you want to leave? Who do you want to leave everything? I understand you have 3 children, you want to leave it to them equally. She can shake her head, with some focus, and I know she's connecting with me. Then I could do a simple will for her.
Yes, and also, if this is in a joint bank account, there's no problem.
Right, joint account would go to the daughter.
Yeah.
Now, I usually tell clients not to do that, particularly on larger accounts, because if mother takes all of her money and puts daughter's name on it, and daughter gets sued, divorced, or has an accident, or has some creditor issue, then mother could lose all of her money because she did that. On that particular question, because it's the $5,000, that might be the best move, though, because there's not much there.
That's the beauty of asking an attorney, because you think all of the things that could happen.
Right.
That could wipe it out.
Lots of.
Yeah, I'm not sure I ever really thought of it till you just said that there are multiple things that could happen that would wipe it out for everybody.
Absolutely.
Yeah, yeah.
Yeah, general advice is not to put your children's names on your accounts, because their problems could jeopardize your accounts.
So if I have a child on my account and she had a big accident or something, they could go for that bank account, right?
Right.
I think I put mine in trust.
Yeah, trust. Now, I always ask people, well, why did you do that? Why do you want to put your child's name on your account? And the answer almost always is to avoid probate.
Yeah.
And I said, well, there's a better way to avoid probate with a living trust, because you are the sole owner of the trust. And even though your daughter might become trustee of the trust, it's all for your benefit while you're living, and then the account still avoids probate upon death. So with a trust, you avoid probate, you avoid guardianship, you maintain ownership. You don't have to worry about your child's creditor problems, and it's a much better way to do it most of the time.
When I was a whole lot younger, say teenager, 20s, whatever, I never heard that much about trusts, but they have become kind of a household word recently. At what point did they kind of become available for average people?
Well, a guy named Dacey wrote a book in the 60s on avoiding probate.
I remember the name of that book.
Right. It was a very popular book. In fact, it was the #1 book published that year, I think. And number 2 is Masters and Johnson's book on sex. So there's a lot of interest in avoiding probate that year.
I'm not sure I get the connection there, but I'll leave it alone.
That's Masters and Johnson. I don't know who they were. They were famous doctors who wrote a book on.
Yeah, I remember them.
I don't even know what the book was exactly about, but I know it was on sexual things between spouses or whatever. And now avoiding probate was more popular that year than that book. But that book suggested you do an individual trust for each asset. A lot has changed since that book, but that made the public more aware of estate planning and using trust in estate planning.
All right, here's another one. If you have a will and a living trust, what happens if you do not put your assets into the living trust, and how do you do that? Should I put life insurance proceeds into a living trust or directly pay out to heirs?
Well, when you do a living trust, most of the time you do what's called a pour-over will. A pour-over will is a will that leaves all the loose ends or things you forgot to put in the trust into the trust.
Wow.
So if you had like 5 bank accounts and you put 4 of them in the name of the trust like you should have, but you forgot one, then that will would leave that one to the trust, but through probate, that one account would go.
It would have to go through probate?
Yeah, because they didn't do what they should have done by putting the asset in the trust. Now, putting assets in a trust is not difficult. It's just a simple name change. When clients leave my office, they leave with an instructional sheet. I do their real estate for them in Florida, because I'm only licensed in Florida, and give them instructions on how to get their other assets in the trust. Insurance is an interesting question because insurance with named beneficiaries does avoid probate and doesn't need to go into the trust.
It goes directly to the beneficiary?
Yes, but, there's always a but. There might be a good reason not to make your child a direct beneficiary. And one of the benefits of trust is trust can handle assets over a period of time. So suppose one of your children has an addiction, has a spending problem, is on special needs with government benefits. If you gave them an outright inheritance, they would lose their benefits. You can have the beneficiary of the account be the trust just because of the special circumstances. And the trust can dole it out over a period of years so they can't spend it all at once. Keep it away from an evil in-law that would spend it all at once, maybe. If they're drug addicted, you can set the trust up to where there's mandatory and random testing, so they get a monthly amount of money, but through the testing, the addiction pops back up, is suspended, but can be used for rehab. Yes, insurance can be set up to have a direct beneficiary, but if you have a special purpose where you don't want them to get a large amount of money at once, you can make the trust a beneficiary and have special provisions in the trust.
That really makes sense, and as I was listening to you, I was thinking same thing over. All of these little caveats that can happen, and this is, I guess, why we have legal people to. When
I get to speak at a group, which I do. In fact, I'm speaking at Indian Rocks Baptist Church tomorrow night, actually. But I'll ask the audience a lot of times, well, how many people here have perfect children? And most of the time, nobody raises their hand.
Even in church.
Once in a while, somebody will raise a hand. I always tell them they're in denial. Because
right.
No perfect children. So there are always special reasons to do special things in estate planning. And you can take care of those in a much more being a good steward way.
Yes, and we have Attorney Pippen's website up right now. And let me address any church leadership who might be listening right now. Especially in the Tampa Bay area, you're available to come and talk to the people. You'd be doing your parishioners a big favor to do that.
Thank you. I get to speak at a lot of churches. I spoke to a widows group on Saturday.
Boy, they need some really direction. I would think.
They need information. Everybody needs information. I was going to share one little story with you that I told you about earlier.
Yes, yes, I want the audience to hear that.
So when I go to a church and speak, there are 3 Christian radio stations that also carry my program. So once in a while, I have a very obvious situation where somebody believes in Jesus as the Lord and Savior. So when that becomes obvious to me, then I ask them, I said, would you like a Christian testimony clause in your will? So yesterday, I had a 96-year-old client die. Her 4 children came to see me yesterday. And I'm looking at the will, and I said, Mom, put a Christian testimony clause in your will. 96 is a good long run, but she's expecting to see you later.
Wow.
And you know, in this particular group, which I'll probably say is unusual, I believe, of course you never know, and I'm not their judge, it seemed to me every person there was a Christian, and every person acknowledged they were looking forward to see Mom again.
I can't imagine the impact of something like that. It's just, my mother left some of that kind of information around. It wasn't in the will, but to put it in an official document like that, I think is...
Yeah, the last thing a child's going to read is their parents' will, something that they sign. It's probably their will.
Yes, and
yesterday the daughter said, would you please read that out loud for my sibling?
Yeah. I wish I could have been just a little mouse in the corner.
It was a neat experience.
To hear that.
It was very...
Yes, and also think of the impact if you have children who are really wandering away from God. And you've just buried them, really. And here's Mom's voice from the grave, you know. It's a great idea.
You know, I've recently read David Jeremiah's book on heaven and Robert Jeffrey's book on heaven.
Yeah.
And I'm anxious to go. It's going to be a great place to go. I'm absolutely looking forward to it.
Yeah, everything is pointing to the end of the age, you know, whether you die or you meet Jesus in the air. Things are about to wind up. Okay, so basically the answer to this one is that even insurance proceeds
they could
go to the trust.
Avoid probate, or they could go to the trust for a special purpose.
Wouldn't the trust be the better choice?
No, the trust, if you're going to leave everything directly outright to your children, then the trust just creates an extra step at that point, because the insurance doesn't go through probate, so it can go directly to the children and not.
But isn't there an expense to probate?
It does. The insurance with beneficiaries doesn't go through probate.
Oh, okay. Okay.
So having it come to the trust just creates an extra step, although you could.
So it's not necessary.
It's not necessary.
Yeah.
Just like retirement accounts.
Okay. Why would anybody set up an irrevocable trust? Is that set in concrete and it's immovable and nobody can change it?
Yeah, most people don't. Most people that create trusts, and the ones that I prepare are living trust. They can amend, change, revoke at any time. An irrevocable trust is not that flexible.
Yeah.
And actually, when you create an irrevocable trust and put something in it, you don't get it back. I mean, it's governed by what the trust says. And the trust might say income only to them. Usually it's for a special purpose. Usually it could be a charitable trust where you're doing it for tax reasons. It used to be you would do an irrevocable trust in Medicaid planning, but now that creates a 5-year look-back period, so it's not often used.
I wouldn't do it.
Yeah.
Of course, I don't make enough to make a difference on that. Can trust control the date of disbursements?
Absolutely.
That's pretty important for some situations.
It's important for minor children, because a trust, you have minor children and you want to leave them, but you don't want them to get it till they're 25 or 21.
35.
Or 35 or 60 as a retirement account.
Hope they'll grow up.
So you definitely can control the distribution in the trust.
Now, what about multiple marriages, and you've got 2 kids with this wife and 3 kids with this wife, and how are you going to divide those assets, and shouldn't the trust be very explicit?
Well, let's say you love your children equally and want to treat them equally, and they have different. One has 2 children, one has 4. Usually, I would say clients would leave equally to their children, and then have a provision if their child is not living, then that portion goes to their children.
Oh, okay.
So most people don't worry about one child has 6 children and one child has 1. I mean, they just treated those equal shares down those bloodlines.
So what if there's a trust, and you've got the trust and you put the assets in it, and you get a divorce? Do you just kind of start all over? Does that make, or you would personally maybe make it null and void and start over?
Well, if a married couple created a trust and they owned everything jointly and had a divorce, now they're separate assets, they'd each create a new separate trust.
Okay. Trusts are more expensive than wills, and they are more complicated to set up, but in the long run, trusts usually save grieving families time and money. That's true, right?
Well, I would disagree. They are a little more expensive. The fee, we publish our fees on our website that they posted, If a couple came in and did 2 wills, 2 power of attorneys, healthcare surrogates, and living wills, those documents would be like $620. If they did a trust, they would get all of those documents plus the trust and the deed to the house for $795. For the extra $175, they avoid probate, avoid guardianship, make it quick, easy, fast, efficient for their children. So
That sounds like the biggest bargain I've heard in a long time.
well, there's a common myth. People think now there are some you should shop around for fees maybe a little bit, because I know we're broadcasting in multiple cities around the United States.
Right.
I'm in Florida.
We're in Florida.
I'm licensed in Florida. I publish my fees. I do know there are attorneys in the area that will charge a couple $1,000s for a trust. So there is a difference on how different attorneys charge on fees. So if I were them, I'd be a good shopper and just call and see how long you've been in practice, how many estate plans have you done, and what are your fees. So.
Yes, and like I said, we got the website up. You can find out how to reach him through that, but you can create any of these documents in the state of Florida, right?
Oh, sure. We have 20 offices around Florida, so we have anybody that lives in Florida I can represent.
Okay. And I've known him for at least 30 years, maybe more, and he's taken care of my situation. And my mother, was she about 98 last time
She was feisty at 98.
I know. I took her to your office, and you asked her a question. She kind of threw it back at you or something. So, but that's when you really, really appreciate an attorney that you feel like you can trust, and he's a believer. He's been a believer, a strong church member as long as I've known him. And you know, we're out of time. So I think you're going to have to rearrange your schedule to come in here once in a while, and we'll answer these questions from real people.
Put me on a monthly schedule. I'll be here.
Okay. I would like that very much. And I just, I get so much satisfaction out of bringing people like Joe to you. And also we have doctors on, we have financial planners on, and we talk about homekeepers. All of these things are involved in keeping home. And I'm very gratified to bring them to you. But we are out of time, so join me next time. Remembering, friends, there's no higher calling than that of a homekeeper. God bless you.
If you should miss a Homekeepers program, you can catch up by going to www.ctnonline.com. Click on CTN Programs and then on Homekeepers.